Welcome to Seeking Disability, the show that helps you in seeking disability. I'm Tom Duncan of Duncan Disability Law.
And I'm Dana Duncan, president of Duncan Disability Law.
Dana, last time we talked about the sequential process and specifically steps 2 and 3, a severe impairment and the listings of impairment. Today, we're here to talk about the residual functional capacity and step 4 of that process, called past relevant work. But before we do, can we just get a recap again on what the sequential process is in evaluating a Social Security claim?
Sure. As we've talked about, it's a legal formula that you have to follow through, and each step has to equate to certain things. Ultimately, if you meet or have this, it may result in you having a favorable disability decision.
Essentially, the formula is there in place as a series of variables measuring the question of whether or not you're disabled according to Social Security's rules.
Correct. And there's some level of complexity to each one, and there's some that are relatively simple, but ultimately it's just the 5 steps. Are you working? We've already covered that. Do you have a severe impairment? Do you meet or equal the listing in the rules or regulations? And then this 4th step is considering what your limitations are. Can you perform your past work? And then the other step is if you can't, then you go to the step 5, which is there other work available in the national economy in significant numbers? We'll cover that next time. Today, we'll talk about past relevant work and what the rules are for that.
All right. So, first off, what is a residual functional capacity?
It's the most you can do given your limitations. So it's a collection. So if you have exertional limitations, there's a finding as to how much weight you can lift, how long you can stand, whether you can do postural limitations, stooping, bending, crouching, crawling, climbing, stairs, ladders, etc. There's also mental impairments. Are you limited to work that's unskilled, that can be learned in a very short period of time? Or do you have limitations in your ability to perform at a consistent pace, deal with the public, deal with coworkers and supervisors, deal with your own situations, or that your mental health becomes disruptive into the workforce?
Essentially, it's taking all of the variables that we've established up to this point based on your severe impairments and your potential limits and how they will affect each of these work related activities and gives you an answer to the equation of how your limitations may impact your eventual work.
Correct. The most you can do.
So, how does that impact steps 4 and 5?
Okay, well, so you take work for as long as the program had been in existence. Social Security had considered work you did within the previous 15 years. That changed last year to 5. And that's primarily because Social Security admitted, after a long time, that the workforce changes and work types of work change abruptly and quickly. Things that were happened a few years ago, as far as procedures and such, there's new technologies constantly coming in that it changes how it was performed. So, 10 years ago, 15 years ago, we had travel agents all over the place. There aren't that many travel agents anymore. And what travel agents do is no longer be on the phone, they're doing it on computers. And so the job has changed significantly. So if you're limited, for example, by migraine headaches, and you can't be in front of a TV screen or a computer screen all day, you can't do your past work, considering it's changed so abruptly. So ultimately, it's what are the limitations in comparison to how the job is done or is being done. And it's only jobs within the last 5 years that count.
So that briefly takes us into step 4, which is past relevant work. You said that now only the last 5 years of your work history counts towards jobs that may be relevant towards this equation. But exactly what is Social Security trying to measure at step 4?
First off, they usually use a vocational expert to identify the past work. Social Security uses an old antiquated system that was developed by the Department of Labor, the Bureau of Labor Statistics, back in the early 1970s. This is called the Dictionary of Occupational Titles. And every job in there has a certain Dictionary of Occupational Title number or code. DOT, Dictionary of Occupational Titles code. And they will indicate what that job is. And that job has certain things where it tells you what the exertional requirements are. Light being lifting 20 pounds occasionally, it's up to a third of the day. Lifting 10 pounds frequently, which is up to 2/3 of the day, or sitting and standing 6 out of 8 hours. The DOT provides you with information about the exertional requirements. It also tells you is the job was skilled, semi-skilled, or unskilled. And there is a companion publication that was issued called the Selective Characteristics of Occupations, which is a big detailed book about that thick that no longer is even being published or printed. You have to get it online, and it tells you all the extra steps like noise levels that are involved in the job and how much vision is required, for example, depth perception and such. And so that gets you into all that. So the vocational expert's supposed to assess this, tell you what the job is. Now, there's very good rules and reasons about having a representative, especially at step 4, that make it very viable for you to have one.
Now, if you had trouble following Dana's line of thought and all of the granular details that were involved there, don't worry, because just about everyone else does too.
Mm-hmm.
Even representatives have a struggle many times to know exactly what the heck he was talking about the last 2 minutes.
I know, and it took me years of work and effort to understand the Dictionary of Occupational Titles, the selective characteristics of occupations, and how it all interplays at step 4, let alone step 5. And quite frankly, I'm not doing this to blow my own horn. I've spent a lot of years studying this. I know it a lot better than some of the vocational experts.
Now, to hopefully maybe take an attempt at simplifying exactly what he went through, Social Security will use essentially all the jobs that existed in roughly like 1977 to 1979 to evaluate all the jobs that currently exist in 2025, 2027, 2029, whenever you're listening or watching to this podcast. And we'll try and apply those jobs that existed almost 50 years ago to jobs that currently exist. Now, remind me, Dad, did the internet exist in the late 1970s?
I don't believe so. Having lived through that time frame, no.
And have jobs significantly changed due to the internet?
Yes, they have. And not just the internet, but other technologies, digital cameras, all kinds of stuff. They used to have tons of jobs that they describe as film developer. How many times did most of you take film to be developed someplace in the last 5 years?
Yes, now everyone just has a smartphone and can take video and pictures on their own.
Yes. And so what ends up happening is you have very outdated job descriptions that don't match up to reality. And you have a lot of problems with vocational experts trying to assess these. What they're doing is they're literally taking apples and trying to compare them to oranges. And other than figuring out it's fruit, you get wide variations of what these jobs are or aren't.
And yet, every day, it seems that there are many different people, thousands, if not millions of claims in a given day, week, month, year are denied at this step, and even more are denied at step 5 based on these classifications. Now, to help
Yes.
everybody understand essentially what we're trying to do here, the reason that Social Security has this step in mind is it applies your RFC, your residual functional capacity of the maximum amount of work that you can do. and tries to figure out whether or not you could return to a job that you already have developed either the skills for, the training for, or the knowledge to be able to do. Because, simply put, the easiest way for you to be a worker in the workforce is doing a job that you've already developed the skills for and returning to a job like that. For example, if you are an accountant and you become handicapped for a certain period of time, you have a nervous breakdown, you start having a migraine issue, you have concussion syndrome from a motor vehicle accident, something to that variety. But you eventually medically improve to the point where you might be able to return to work. The easiest job for you to go back to is accounting because you've already developed the skills necessary to be an accountant. And so they basically say, all right, because you have all this skills and training in one particular area, let's use the path of least resistance to see if you can still maintain employment. Because disability is ultimately a question of whether or not you can maintain competitive full-time employment. And I slow down and progress through certain phrases repeatedly for everyone's benefit here because they're the same ones, just drilling these phrases down consistently. Now, Social Security, in their great favorable wisdom, finally allowed us some maneuverability. As Dana indicated, they've recognized that the internet and smartphones and all the vast amounts of technology within the last 20 years has essentially made the evolution curve of the job market that the job that you're doing right now may be completely obsolete 5 years from now.
Correct.
And so
They
because
finally
of
got
that,
around to figuring out that people do not use horses and buggies.
they have limited it from the 15 years that it used to be down to 5. And what you need to do is you need to go through each one of your past jobs over the past 5 years, or potentially back longer, depending on when your insured status ran out,
Yes.
and figure out whether each of those are jobs that, based on what your estimate of your residual functional capacity is going to be, will be jobs that you may or may not be able to still perform.
Correct. And it can be very complex. And ultimately, it's the vocational expert testifying about it is what the judges usually rely on. If you don't have somebody who knows what they're doing, they're going to just possibly do nothing and you might lose at step 4. Whereas a skilled representative will be familiar with the DOT and may say, well, don't you mean that this job instead of that one? That other job that you cite maybe have a higher residual functional capacity, which means that if you have one that's more restrictive, you can't do your past work. The other thing that can happen is how many times, and I always use this example. I had a case where a woman was a cashier and she was 55 and limited to light. And if you just have that, she could go back to being a cashier because cashier is a light job. But what her ultimate situation was is when I asked her about it, she also worked at this, her cashier job was working at a feed store. So she was selling dog food, cat food, bird seed, etc. She had to carry the 50-pound bags out to the car for the customer. Well, that's beyond light work, which is maximum of 20 pounds lifting. And as a result, I got the judge to agree that, and the vocational expert, that this is called a composite job, where there are two different jobs that are being done at the same time, cashier and material handler. You ultimately, in a combined setting, take the higher level of exertion and requirement and skill level. So material handler was medium, both were unskilled. So it becomes now a medium job. She could not perform it when she was limited to light work. So therefore, she was found disabled. Again, knowing how to develop the record and how to prevent and ask the questions, how to prevent the vocational expert from giving a very cursory review and giving a job that's going to hurt you, knowing how to structure stuff and how to ask the questions of you during the examination to show that this is a composite job could be the difference between winning and losing.
So, this brings us to kind of an enigma in Social Security law: transferable skills. What are they and why they matter?
Well, transferable skills, and you can have this argument with vocational experts all the time. They confuse skills with abilities or with functions or aptitudes. Okay, skills are things that you have to learn or be taught. For example, a skill is knowing how to read a blueprint. A skill is knowing how to manage people. Okay, an aptitude is you have a good knowledge of math. You are well organized in the workplace. Those are aptitudes. So these skills have to be such that you can use them in another type of job. So it's very common, for example, if somebody is in construction, their ability to do roofing may have transferable skills, knowledge of roof materials and roof stuff. Sometimes they could say, well, you could use those as transferable skills into a job where you're overseeing roofing as opposed to actually doing the roofing. And so that is something that has to be taken into account. It is very complex. You need to be well prepared for cross examination on transferable skills before the hearing ever starts. If all of a sudden you decide or hear that there are transferable skills now, doing that at the hearing and being able to open the materials necessary to do anything about it is going to be very difficult. It's not impossible, but it's going to be difficult. The representative needs to be well prepared most of the time in advance to address it.
So, how does age and education impact transferability of skills?
First off, age can impact because there are different standards for transferability when you reach certain ages. It's a little tougher from ages 55 to 59, but not much. The key one is ages 60 and above, because there you have to have transferable skills that allow you to transfer into another job of a similar industry with similar functions and such. For example, if you can read blueprints and you're in the construction industry, the ability to transfer into a job that is a machinist or operating machines that use blueprints, that's not a transferable because you can't change into the industry without a substantial change in functions and responsibilities. So that is not a transferable skill. 60 is kind of the point where transferable skills become more difficult to use to establish that you could do some other similar type of work at that step 4.
Okay, are there some practical tips for either claimants or other advocates who might be listening to this show now or in the future?
Number 1, make sure you understand the job being performed. Number 2, have them outline all the responsibilities and duties. For example, if you're working on and I know of places like this, if you're working at a place where they have you on the mini taco line one day and your job is to make sure all the mini tacos line up so that they get the amount of meat in the shell, and the next day you're on the cream puff line and you have to make sure that all the cream puffs are put into a certain way, you better put that down that you're changing jobs on a regular basis. Because if you have limitations in your ability to change jobs or change functions on a day-to-day basis, that may be prohibitive of being able to do that past work.
Make sure you ask your claimant, or the claimant goes through all of their work history, probably for the last 7 to 8 years. I know that 5 years is the limitation, but there are some times where some other jobs might pop out at you, or they lasted a little bit longer, or something to that effect. And it's good to have a nice timeline and detailed job descriptions of all the jobs, how were they were performed, all the job duties and requirements, and the age and education at each of these stages that might be relevant to how a vocational expert might testify at a hearing and how it might eventually impact the claim.
Yeah, and quite frankly, I could go into it and I'd lose most people, but there's a wrinkle in transferable skills and past relevant work that has to do when your date last insured expired. And you need somebody who understands it to do it properly.
So, in essence, we need the answers to things like how much weight that you lifted in each job, accurate standing, sitting, and walking requirements for the jobs as they were performed. If you were a cashier, more than likely you were walking and or standing most of your given day. If you're a waitress, same thing. Certain jobs have certain requirements. Yet, when you're a receptionist, most of your day is going to be spent in a seated position. All of this is stuff that is going to be relevant to how it will be impacted eventually in a Social Security case and could be the difference in winning or losing. Dates of employment. I cannot stress exactly knowing exactly roughly the month, at least the month, if not the exact day, when a job started and ended can also be extremely beneficial to your case. If the job did not last for more than 30 days, it probably is not a job that can be taken into account for past relevant work.
One of the things I would stress is if you tried to do the job and they fired you for not being able to do the job, that's a pretty important thing to make sure a representative knows.
So, just to recap everything that we've been through up to this point, we went through again the sequential process, and today we were talking about the residual functional capacity, which, as a raw definition, was an estimate of the maximum amount of work activity that you might be able to do and how it might relate on your ability to do either your past jobs or future jobs, other jobs that might exist, which we will cover in the next episode. And then we talked about past relevant work, which is step 4 of the sequential process, whereby Social Security will estimate whether or not you might be able to return to a job you did previously based on your skills, your education, your understanding, and your previous training.
Correct. So, and again, it's a term of art more than anything, because you sometimes have to make sure that you hold vocational experts accountable for what they're testifying to about the jobs, because there are so many jobs that are very similar, that are described similarly in the dictionary of like occupational titles. You really need to know what the jobs are and be able to articulate what's the most favorable finding that the vocational expert can make.
And as always, we would suggest highly that because of the complexity of both this and every other variable within the sequential process, please consult an experienced representative or firm on how to navigate your way through these claims. It is imperative that you try and not do this on your own.
Correct.
Of course, there's a lot more information to share, but that's a good place to stop for this episode. If you have more questions about disability, you can visit our website, duncandisability.com, or call 1 888 458 2406 to talk to the Duncan Disability staff. Thank you for listening. We'll see you next time. Seeking Disability is a production of Ronnie Duncan Studios. This show is written by Dana and Thomas Duncan. It is mixed, edited, and recorded by Thomas Duncan. Our music is thanks to Purple Planet Music. Our technical provider is Riverside FM, and our distributor is Captivate FM.